Good evening, everyone, and welcome. My name is Victoria Williams. I'm a program officer here at the Chicago Council on Global Affairs. We are pleased to welcome Tom Ginsburg and Aziz Huq to the council this evening. Their new book, How to Save a Constitutional Democracy, will be available for sale and signing after the program from our partners, The Bookseller. Most of you know our house rules, but for our guests in the room and online, please note that we are on the record and that we are live streaming this event. Please silence your cell phones, and views expressed by individuals we host are their own and do not represent institutional positions or views of the council. And thank you to our members in attendance today. Your support is critical to our work. If you are not yet a member, please consider joining us. We have a wide range of levels for you to choose from. Returning to today's program, today's conversation will be followed by audience questions. We'll be taking questions from in the room and from online at chi.cnf.io, and you can see that the link is on either side of the screens. Now, by way of brief introduction, our speakers today are Tom Ginsburg. He is the Leo Spitz Professor of International Law, and he is a research associate of the American Bar Foundation. He's also a professor of the political science at the University of Chicago Law School. He currently co-directs the Comparative Constitution Project, an effort to analyze all the constitutions of independent nation states, and he serves as a senior advisor on constitution building to international IDEA. And Aziz Huq, he is the Frank and Bernice J. Greenberg Professor of Law, Master Classer Malone, and Teaching Scholar at the University of Chicago Law School. He also serves as Senior Consultant Analyst for the International Crisis Group and clerked for Judge Robert D. Sack and the U.S. Court of Appeals for the Second Circuit and Justice Ruth Ginsburg of the U.S. Supreme Court. I'll return to moderate audience Q&A, but for now, please join me in welcoming our distinguished speakers.
Thank you so much, Tiffany, and thanks to all of you for coming. Our book has just come out, so it's really an exciting week for us here. And the political scientists who study democracy and measure it think that the number of democracies around the world peaked somewhere around 2006. And every year since then, there have been fewer and fewer democracies. This has affected countries that people thought were going to be stable democracies, like Hungary and Poland. It's affected countries which were sort of on the margin, like Turkey. And it's affected countries that were long-standing democracies. Venezuela was a democracy for several decades until that really ended last year. Most worryingly, we're seeing in advanced industrial economies forms of populism, forms of anti-system party, and so that the degradation is now even creeping into rich democracies as well. And in fact, among some measures, the United States, the Economist Intelligence Unit last year actually degraded the United States, downgraded it from being a full democracy to a flawed democracy, a category that also includes Israel and Japan. And this is the result of a complicated index that they have. In the case of the United States, they attributed a lot to our electoral system, the way we run or don't run elections. So it's a moment of great concern around the world. Now, for Americans, we're accustomed to thinking, well, whatever's happening in the rest of the world doesn't really affect us. American exceptionalism. We are unique. We have this fantastic Constitution. It's 230 years old. Surely it will protect us from these forces which are buffeting the democratic systems of other countries around the world. And one of the things we interrogate in our book is to really ask that question. Would the U.S. Constitution save us if we were to experience a charismatic populist leader or a party that wanted to defect on democracy, hypothetically? What would happen? How would we do? And what we show is not only would the U.S. Constitution fail to protect us, but in many ways, it and the way it's been interpreted facilitate democratic erosion. Now, to really understand that process, we have to really then analyze what are the processes by which democratic erosion takes place. And it's a kind of standard feature of the constitutional imagination that democracy tends to end quickly. So when people imagine the end of democracy, the paradigm is something like a military coup or a communist revolution, a very quick collapse of a democracy. And one of the things that we show is that this, if it was ever the modal case, is no longer the case. The way democracies end now, the way democracies are hurt, is through a much slower process. So the fast process of democratic collapse is not really much of a threat, certainly not in the United States. But the slow process of democratic erosion is a very real one. And a characteristic of that process, as we look around the world, is that it takes place through a series of discrete steps along several different dimensions, each of which on its own might seem to be very minor and might not seem very worrying. But when you add these things up, and when there's enough of them, we would say, well, the democracy has really eroded in a fundamental way. There's been a qualitative decline in the level of democracy. So what our book is trying to do is to leverage all that data from the rest of the world to bring it to bear here on the United States and to ask how we would do and how our constitutional order would do and will do when faced with such a challenge. Now, what we do is we lay out sort of 5 channels by which democracy erodes, 5 dimensions. Maybe I'll turn it over to you for.
Yeah, let me step back and put the role of the law in ending democracy into a context, and then building on what Tom has said, tell you about the particular ways in which we see law playing a role in the decline of democratic quality. I'm sure that many of you are aware and have read some of the articles and books that have been written about the observed decline in the quality of democracy around the world in the last few years. And by far, the majority of those books and articles and editorials worrying about democracy have focused upon the background conditions under which democracies come under strain. The fact that we appear to be in a moment at which there is a great deal of anxiety about economic insecurity in the context of financial and trade-related globalization, and anxiety about cultural changes, right? The way that norms and values appear to be evolving rapidly in a way that make at least some people uncomfortable. And it's a common observation that some combination of cultural and economic anxieties has propelled to power in many democratic countries, ranging from Latin America through Europe to the Middle East, leaders who claim a particular kind of political authority, leaders who claim to speak directly in some way for the people. And that's what's generally called populism. And there's much hand-wringing about populism and whether populism truly is a form of democracy, and where it comes from and how it can be extinguished. So we think that all is very important. But there's a piece that we think has been missing from the puzzle. And that is the way that the populist or the anti-democrat, in fact, unpicks slowly, piece by piece, the logic of democracy once they are in power. And this is where the law comes in. Looking around the world at the Latin American, Eastern European, Middle Eastern, and Asian examples of democratic backsliding, as we call it, what one sees is a consistent toolkit. There is a consistent packet of what you might think of as legal technologies that have emerged and been honed and then disseminated around the world, much as ideas and laws and values have been disseminated around the world for hundreds of years, right? Adopted, picked up, and deployed by different rulers in different places. What's characteristic of this package of legal and constitutional tools that are deployed against democracy is that they are almost all consistent with the rules of the game that existed under the old democratic disposition. What's genius in a way about them is that they exploit implicit weaknesses, paradoxes, and contradictions in the legal frameworks that underpin democracy as a way of making democracies weaker. We shouldn't be surprised to see diffusion, right? democracy itself, after all, has diffused around the world in what the political scientist Samuel Huntington called a series of waves. And today, as the historian Timothy Schneider has very eloquently argued, there is one particular global power, Russia, that has first perfected a set of tools and then consciously exported them, first to the Ukraine, then to Hungary and Poland, right? So the idea that there would be a diffusion of anti-democratic tools should not surprise. So what are those tools? What if you were worried about the future of democracy and you were looking overseas and trying to figure out, how are the particular steps taken to unravel democracy? What am I looking for? Right, I think there are 5 key signs, and what I can do is I'll lay those out briefly and then give you one very quick example from around the world of each of them, and then maybe we can talk a little bit about the US case in a bit more detail. So the first of the 5 is the use of the constitutional amendments to undermine the quality of democracy. Right? This comes very quickly to populists. Populists claim a particular mandate to speak for the people without regard to the messy details of political representation through electoral colleges or 2-stage voting or the like. Right? Populists claim to speak distinctly for the people, and therefore the idea of amending the basic law in one way, shape, or form pops up again and again and again as a key move that populists make against the quality of democracy. Probably the best example of this comes from Venezuela. After Hugo Chavez came to power, he found himself confronting a hostile legislative body, hostile courts, and by and large, a set of bureaucratic elites that were none too happy with the prospects of the Chavista political project. So rather than confront those directly and engage in the ordinary back and forth of policymaking, Chavez called a constituent assembly. He invoked the people. And he used the Constituent Assembly as an instrument against the legislative and the judicial branches. Right? So that's one example of the way in which a constitutional amendment power can be deployed against democracy as a going concern. A second way in which democracy can be undermined is by an attack on what, in America, we have come to call the separation of powers. This is the idea that there are distinct functions of government. Somebody writes the law, somebody implements the law, they execute it, and then somebody else adjudicates, judges whether the law has been violated. And it is canonical since James Madison that the existence of these divisions in a governmental authority has the effect of checking the ambitions of anti-democratic politicians. Right? The separation of powers is justified in the Federalist Papers as an anti-tyranny device. Consistent with that notion, what one sees around the world is, in particular, attacks on courts as institutions that are potential serious road speed bumps or guardrails against democratic decline. A good example of this comes from Hungary and Poland. Right? In Hungary, you have a party called Fidesz that came to power in 1997. In Poland, a party called PIS came to power in 2010. Some difference in, sorry, not 2000. I got the date wrong, didn't I? It's not 1997. It's later. Sorry, 2011. In both instances, one of the first things that the government did, the Fidesz and the PIS government did, was to lower the retirement age for judges. The effect of lowering the retirement age for judges was to purge the judiciary of a suite of judges who were not on the same political page as Fidesz or PIS, right? So the purge of the judiciary was accomplished through a purely legal means, right? So that's an example of the judiciary being purged. The third way in which we see anti-democracy, democratic backsliding play out is by attacks on non-branch level independent actors who serve as checks on anti-democratic moves. Right? Most constitutions now operative in the world today do not limit themselves to 3 branches of government. They also create a suite of independent freestanding institutions that are designed, that are meant to impose constraints upon the misuse of government power. So things like human rights ombudsman, things like a independent media monitor and regulator, things like a prosecutor responsible for checking graft and official corruption, right? The average constitution has 4 of these around the world. These institutions also find themselves at the end of the spear as soon as a populist government is elected. So for example, in Hungary, you also saw a process of constitutional amendment soon after Fidesz came into power. And one of the changes that Fidesz engaged in was a reworking of, in particular, the media board and the body that was responsible for monitoring fiscal and monetary policy. So that's constitutional amendment, checks and balances, independent institutions. The 4th and 5th tools used by the anti-democrat are probably more familiar than others, so I'll skate quickly over them. The 4th is a tax on the public sphere, right? So here you see measures such as the use of regulatory or antitrust law to shut down newspapers, to squeeze out companies that provide services to opposition political parties in ways that, although formally there's no censorship, functionally opposition voices cannot make themselves heard. Right? And then the final measure is the use of manipulation of voting and political representation rules to end democratic competition. Right? A good example of this is Venezuela, where after a political opponent of Hugo Chavez won the mayoralty of Caracas, the national government amended the national law to move all of the mayor's powers away from the mayor to a new county-level body. Right? It's as if your political opponent wins the mayoral contest in Chicago, and then his enemies in Springfield just move all the power from the mayor to the person who runs Cook County. Right? So those are the 5 measures. Right? And I think the question that they raise is which, if any of those, might play out in the United States, given our Constitution.
Right, so one way to think about it is how would our Constitution do in such circumstances? There is, of course, one dimension in which the United States truly is exceptional, and that's the age of the Constitution. It's the oldest such document in the world by a good degree, 230 years old, and in that sense, designed for a very different world. And one way to think about it is that we're using, in this one realm, 18th century technology to govern ourselves when we would not think of doing that in any other realm, right? No one came here in the horse and buggy or anything like that. And so how does this technology hold up? And one way to, what we do is we sort of go through those various modalities and sort of, you might say, grade the Constitution. So the first one, as he's mentioned, was constitutional amendment. And here, of course, the US Constitution does pretty well. It's really hard to amend the Constitution, maybe too hard, but that at least prevents opportunistic kind of lock-in by particular forces which just win one election, as Orban did in Hungary. One of the consequences, though, is because it's so hard to amend the Constitution, we rely very heavily on the courts for updating the Constitution, and that raises the stakes of the Supreme Court seats such that we, as we all know, we're now fighting elections over who gets to appoint a Supreme Court justice. Really crazy when you think about it. That should not be how a democracy functions, where the judges and judicial appointments are a central issue. But they are in part because of that difficulty. Nevertheless, we do okay on that dimension. The checks and balances. Well, we're all taught, this brilliant system of checks and balances designed by James Madison and such. We have to remember that he designed that system before there was such a thing as the modern political party. And he said, let ambition counteract ambition. What we, as scholars, when we look at the courts and Congress acting to defend their institutional interests, we don't see it very often, particularly in periods of unified government. Those institutional interests fade away, and the partisan interest kind of dominates. And that's neither good nor bad, but it does suggest that the design is insufficient, and certainly for our current environment in that sense. A third dimension is what we call the bureaucratic rule of law. These sort of faceless bureaucrats that are observing the rules that are to some degree insulated from whoever happens to be running things at the top. And here the United States does not do that well. And some of these institutions, really very obscure, are starting to appear in the news. Things like inspectors general. Every federal agency has an inspector general who will go audit and produce reports when something goes wrong. We don't really, those are very important institutions. They're not really protected very well. They can be fired by the heads of agencies. In terms of rule of law investigations, we don't really have very good protection. The special counsel, which is now, of course, in the news virtually every day, is really just the product now, not of statutory protection, certainly not of constitutional protection, but is produced by a regulation of the Department of Justice. And so not really well insulated from partisan manipulation there. And so we think these institutions need much more attention. Another dimension that we look at is elections. And here the United States just really does not do very well. Again, you could lay some of the blame at Madison's feet. Madison was writing the Constitution, or working on the Constitution, before there were political parties, and so he gave the management of elections to who? The state legislatures. That's who draws the lines in most states. And we have now partisan secretaries of state who are, managing elections. That office has actually been sort of corroded in recent decades in the sense that, at least when I was a kid, it was sort of a faceless office. Maybe it was one party or another, but in the same way that we're going to vote for the coroner next week. No one really took it very seriously as a partisan office. But in the last couple decades, we've seen a lot of energy, partisan energy, put into those offices. And now in this election next week, we have 2 secretaries of state who are running for governor and will be counting the votes in the elections they are running. So that seems to me a degradation of any basic standard of what the British would call natural justice. Never be a judge in your own case. So that's a dimension which we don't do very well, and certainly there's a lot of room for improvement. The public sphere. Well, this is a dimension where we think the United States actually maybe does as well as we can hope. That is, what is the alternative to having a very open First Amendment? Which really does allow, or assumes, that the culture will police itself. Well, one set of tools are very popular in Europe and other democracies, which is to allow the government in some form to police democratic space, to guard against undemocratic parties. And so you have bans of the Nazi Party or the Communist Party in West Germany. Recently, South Korea banned a pro-North Korean party. Also hate speech regulation and things like this. We actually are very skeptical of those tools because if you think about it, they could easily be turned against democratic forces as they are in places like Russia and Turkey. They're not inherently good, they're liable to abuse. And so actually this is one dimension where we think the US Constitution does pretty well. So that's our assessment. We give it, I guess, a qualified, a B minus or C or something like that if we were to grade it. But the other thing that we try to do is come up with some workable solutions.
Let me just add to the list of criticism of the Constitution, because I think it's useful to give a couple of examples that are salient to recent events that put a little bit more of a knife edge on that. So Tom said that the fact that the Constitution is really hard to amend is a good thing, in the sense that you won't see what happened in Venezuela, first under Chavez, then under Maduro, with the creation of constituent assemblies to entrench their own power. You won't see something akin to what happened in Turkey with Erdogan going to the people and saying, give me more power as president. But the downside of a difficult to amend constitution is that there's pieces of text that are in the old constitution that turn out to create unexpected problems over time. And let me give you two examples of that. So the first is the fact that the president, under Article 2 of our Constitution, has pardon authority. The text of the pardon clause, however, does not say anything about whether the president can pardon himself. Nobody at the time of the Constitution's drafting in 1787 thought to ask the question, well, should we clarify that a self-pardon is or is not lawful? And to be sure, there are arguments that the structure and the function of the pardon power clause in the larger scheme of the Constitution precludes a self-pardon power, right? It's a form of being a judge in your own cause, which is a principle that is thought to animate much of the Constitution, but there's nothing in the text. Or think about the proposal that the president made earlier this week with respect to birthright citizenship. It is, I take it, the conventional wisdom, and it's a conventional wisdom I share as a normative matter, that the text of the 14th Amendment, which was enacted to repudiate the Dred Scott decision prior to the Civil War that declared that African Americans, whether slave or free, could not be citizens, right? The text of the 14th Amendment citizenship clause was intended to repudiate Dred Scott. And that was thought to reach everybody. Turns out, though, that the text of the 14th Amendment says that anyone born in the United States and subject to its jurisdiction, right, shall be a citizen. The argument that Trump is implicitly making, he's not directly making it clearly, is that that clause in its jurisdiction excludes the children of undocumented migrants, right? Well, how do we know that he's wrong? It turns out that it's very unclear what the phrase in its jurisdiction means. I could whip up an argument for why it doesn't exclude the children of undocumented immigrants, but it's not on the face of the text. The text itself is magnificently ambiguous and therefore much more potent, much more capable of taking on different partisan shapes and blades than you would first think, right? So having a hard-to-amend constitution is a good thing because it takes out of play the Chavez-Maduro-Erdogan risk. But notice that it creates these other risks, right? The risk of old, badly drafted text that doesn't anticipate the gamesmanship of today. Okay, that's the first weakness in the Constitution. Here's another one. We think of our federal courts as being independent, right? It's not a phrase actually used in the Constitution, but we think of the Supreme Court and the lower federal courts as being independent from politics. Well, how are they independent? In what fashion are they independent? They are independent because judges cannot have their salary reduced and they cannot be removed, provided they show something called good behavior, right? Now that's the back end, right? That's the back end. But everyone who's been involved in hiring knows that for the most part, the way you elicit a workforce that conforms to your wishes as an employer is at the front end. You hire the right people. Very rarely do you actually fire people, right? Well, what does the US Constitution do in terms of hiring judges? It places that power into elected bodies, the presidency and the Senate. why on earth did the framers think that vesting the authority to appoint judges in a pair of political actors, a pair, by the way, that's going to be closely linked ideologically because of the similar demographic effects of the Senate and the Electoral College, right? Why did the framers think that that was a way of getting a judiciary that was independent from contemporaneous political powers? Well, Alexander Hamilton tells us in the Federalist Papers, he says, look, there are so few men who have mastery of the law, right, that they would be eligible for the position of a federal judge, that we have no reason to expect that there would be gamesmanship in the appointment of federal judges. So we don't need to worry about the manipulation of who gets appointed to the federal bench, because they've all gone to Georgetown Prep. He didn't say that. The third example is a seemingly innocuous clause at the beginning of Article 2 of the Constitution, which says there shall be, so something to the effect of, there shall be one president. Right? Why does it say that? Because in Philadelphia in 1787, there was a debate. There was a debate about whether there would be a council structure atop the federal government, or whether there would be a single elected person, right? And the advocates of the singular pinnacle to the federal government won out as against those who argued for a council. Subsequent judges and justices, particularly those who have worked previously in the executive branch and who carry with them the sentiments of a former executive branch lawyer, right, which is a majority of the Supreme Court at the moment, perceived in the opening clause of Article 2, right, the choice to have a single president as opposed to a council, a different idea, an idea that they call the unitary presidency. And the notion of the unitary presidency is that the Constitution does not just create a pyramidal structure, right, with the president elected by the Electoral College mechanism. It also, notwithstanding the fact that nothing in the text of the document says this, requires that everybody under the president be subject to his or her unfettered control, right? And there are different flavors of the unitary executive theory. One flavor focuses upon the power that the president has always to overrule any policy decision that a subordinate might take. And a different flavor, this is the one that was championed most by the late Justice Antonin Scalia, focused on the idea that the president can always fire someone who is within the executive branch. Right? The president always has to have absolute power to fire anybody within the executive branch. Well, in a constitution that lacks the kind of freestanding institutions like the public protector or the ombudsman that other constitutions have, right? And which relies instead on what Tom labeled the bureaucratic rule of law as exercised within, say, the Justice Department, or the Office of Government Ethics, or the Department of Health and Human Services, or the Department of the Interior. Think about the effect of the unitary presidency theory. One consequence is that the office of a special counsel, a person who is subject to limited, although real, control by the president, right, is arguably unconstitutional. There is already a motion made by one of the defendants charged by Robert Mueller to vacate the indictment against him on the ground that the special counsel's office is unconstitutional pursuant to the unitary executive theory. Or think about the possibility explored recently in a fascinating Politico article that the special counsel subpoenas the president. Right? It's easy to assume that just because there is an old precedent, an old holding that goes by the name of United States versus Nixon, that says that the president can be subpoenaed in the context of a criminal investigation, that the present Supreme Court will say that such a subpoena can be enforced. Given, however, the expressed loyalty to the unitary presidency theory of several, perhaps a majority of the current Supreme Court, I don't think there's any reason to think that should that subpoena be challenged all the way, if it does exist, should that subpoena be challenged all the way to the Supreme Court, the president wouldn't win, right? Which would mean that there was no entity, no court, no prosecutor, no committee, certainly, of either the House or the Senate, that could extract information about legal violations, wrongdoing on the part of the president, or perhaps also his close associates, through the law. Right? That would be the consequence of the unitary executive theory. Indeed, it might well be the consequence within the next couple of months. The nice irony, or the irony, whether it's nice or not, I think depends on your view, of the unitary presidency theory is that it is justified in the name of democracy. It is justified on the basis of the claim that the president is elected. And therefore, if the president has control over everybody else, that serves democracy. But that's a very simple fallacy. It's a fallacy of composition. Right? It's the idea that for a system as a whole to be democratic, every part of it also needs to be democratic. That is just not so. Right? A system that maintains democracy as a going concern has to have within it an awful lot of elements that themselves are not democratic. Right? And that's a theme that runs through our kind of taxonomy, so to speak, and what we see happening around the world, which is that it's often not the pure exercise of democracy that's attacked. It's often the non-democratic institutional supports of democracy that are targeted first. And for the reasons that Tom explored and that I just gave, there are many ways in which those institutional struts in the United States are not just vulnerable under the Constitution. The Constitution itself is easy to weaponize against democracy.
Let me just say a little bit about very quickly about what to do. What's the positive agenda? And then we can open it up for questions. So I don't know if many of you know that there are two ways of amending the American Constitution. The one we all learn in grammar school, 2/3 of both houses of Congress and then 3/4 of the states. But then there's another provision in Article 5, which allows 2/3 of the state legislatures to call a new constitutional convention. And we are actually at the point, there's a movement on the right and also one on the left, which has been less successful, to produce calls, each of them trying to amend just particular provisions. So on the right, they want to have a balanced budget provision. On the left, there's a movement to overturn Citizens United through a new constitutional convention. And we're actually getting to the point where, depending how you add these things up, we might have the requisite number of states. So what should we do if we were to get to that point? First of all, we don't think it's a good idea. In the current state of American politics, you can imagine the kind of things we'd fight about in a real constitutional convention. But many of the things that we've talked about, the institutions that we've talked about, are things that we would want to constitutionalize accountability infrastructure, to take elections from partisan bodies, to reduce the term of the Supreme Court from life to something like 15 years or something like that, have a constitutional court. These are things which other constitutions have done. We also, though, recognize that constitutional amendment is very unlikely here in the United States. And so we have thought a lot about other things that could be done at the sub-constitutional level, either at the level of statute or even at the level of congressional rules, which would be pretty easy to implement if the political incentives were aligned. I'll just give one idea in the latter regard. So many democracies around the world have an official person who is called the head of the opposition. In a parliamentary system, there's an official leader of the opposition. And that is a really good thing symbolically, because it recognizes that the opposition does have a role to play in a democracy. If there's a constitutional opposition, you can't demonize them in the same way that we now see the parties demonizing each other and such here. More importantly, giving the opposition some rights in the legislative process, certain committee chairs, super majority to appoint judges, which we used to have, of course. These are things which could be done simply by congressional rule, the rules of each House of Congress. So there's some feasible reforms that are within our reach. And then there's, obviously a much larger agenda. To me, the number one thing, and then I'll turn it over to Tiffany to handle the questions here, but to me, the number one thing really is state legislatures moving to technocratic ways of running elections instead of having partisan bodies in charge. There's about 14 American states that do have neutral electoral commissions, nonpartisan electoral commissions to draw the boundaries and stuff. And we know that those elections are more competitive and more responsive to changes in public opinion than the rest of the states. Well, we really do want to hear your questions, so I think we'll turn it back over to Tiffany.
All righty, we're going to open it up to questions. We have microphones in the room. Please raise your hand if you'd like to ask a question. The microphone will come to you. I'll go just right up here in the front.
I have two questions. One is, it seems that the executive branch over the last 40, 50 years has been given more and more power from the legislative branch. And I'm wondering if my first question is if you wonder, outside the realm of the Constitution, but whether the legislature, given what's been happening, has the ability to reassert some of those responsibilities. For example, trade, I would say. The other question is, you talked about the Supreme Court in terms of lifetime appointment. And I'm curious, both as it relates to the Supreme Court and our legislature, there's the House and the Senate, as to when you would, what was the life expectancy when the Constitution was written?
Yeah, maybe the life expectancy when the Constitution was written was about 60. So, it had a very different meaning than now. The point about the gathering of power in the executive is something we actually observe all over the world. Legislatures in every country are not very popular. And so we're not alone in that regard. And it's just something about the demands of modern government, the need for speed, the information, have led to a shifting of power to the executive. The key thing then becomes making sure that the executive is held accountable, that the legislature can play its role in that regard. And also, I believe, connecting the executive to parties that are grounded in the society. In many democracies, we see a lot of executive lawmaking with very weak parties. So Brazil, the presidential election in Brazil, the party which Bolsonaro ran on, basically a non-entity. It had 60,000 votes in the whole country during the last election. Now it is his vehicle. The legislature in Brazil is very dysfunctional, and so there's a lot of concentration in the executive. India, you might say, is pretty similar in some regards. And so it's a real concern that parties wither and all we have is the personality. And that's why I think institutionalizing executive accountability is really critical.
We'll take a question from this gentleman right here. Yep.
So in your views, what are the effects of money in politics on democratic erosion? And if there were to be problems with this, what are some possible solutions to that?
The pattern of democratic erosion that one sees around the world is not limited to jurisdictions, to countries in which the relationship between politicians and their donors is quite as unregulated as in the United States, right? And the forces that seize power and use the kind of tools that we described can come to power in the absence of any kind of support from moneyed interests of the kind that are criticized in the United States, right? So I think that was true in Venezuela, in Turkey. Erdogan came to power first on the basis of his effective management of Istanbul as mayor, right? He came in as a technocratic, competent administrator, and also as somebody who appealed to a vast, increasingly wealthy middle class who had felt locked out by the previously secularist dispensation. So I don't think that looking around the world, you can see a clear connection between the size of the role of money in politics and the magnitude of the threat of democratic erosion. That doesn't seem to be what's driving it. At the same time, it is surely the case that part of the dissatisfaction with particularly Congress in the United States is the fact that the chances that your or my opinions influence or are correlated over time with the policy choices of legislators, particularly our legislators, is pretty small to negligible unless we're within the top decile of the wealth stratum, right? That itself induces a particular form of skepticism that can lead into the anti-elitist politics of the populist anti-democrat. But I'm not sure that if you were to have a flatter system, or a system which was more porous and open to, less porous to money and more porous to public, broadly held preferences, you wouldn't have backsliding, right? Certainly in European jurisdictions like Germany, where the AfD has made real inroads, like France, where the former Front National has made inroads, you do see substantial gains by anti-democratic, anti-system parties in the absence of the kind of pathologies that you see here. So I don't mean to underplay the importance of the problems of money in politics, but it's not clear to me that they're the same problems that we're talking about, if that's helpful.
Take a question just up here.
During the Great Depression, there was certainly one of the highest levels of economic anxiety we've ever seen, and there were severe threats to American democracy and some slippage of various sorts, and yet the system held. Are there lessons from that experience, or is our situation now so radically different that we can't really learn from that?
Can I you can answer it, but I think that it's important to remember that at the time of the Great Depression, much of the South was a one-party, functionally autocratic country, right? The standard political science description of the South is as a form of authoritarianism under the Democratic Party, in which a substantial portion of the electorate, all African Americans, were locked out, right? So when we talk about the United States as having a well-functioning democracy, historically, I think first one has to remember that women didn't have the vote until 1919, right? That's half the population. And then second, African Americans were locked out, and you had a system, at least from the 1890s until the reforms catalyzed by the Voting Rights Act of 1965, in which one-party rule was the dominant regime in the South. As for the Great Depression, there were calls by people like Walter Lippmann for Roosevelt to assume dictatorial powers akin to that exercised by Mussolini in particular, who was much admired. Hitler was much admired too. the feeling was mutual. Hitler admired lots of US immigration policies and Jim Crow. There were real commonalities, that is, between the democratic regime, the big D democratic regime, in power through much of the 30s, and some of the fascist regimes in Europe. Now, what seems to have mattered in that period of time was the particular and distinctive character of FDR himself, right? FDR himself, notwithstanding the fact that he broke the then prevailing norm against more than 2 presidential terms in office, right? FDR appeared to have no dictatorial leanings personally. Now, imagine an alternative history in which Huey Long, the former governor of Louisiana, someone who was overtly populist, elicited violence and engaged in massive corruption, ends up in the Senate. Imagine he had been in the White House. Then I think you would have had a very different story playing out in the Great Depression. So it's the kind of answer that, he's a political scientist, I'm the lawyer. It's the kind of answer that drives the political scientist a little crazy. But I really think that the identity and the particular character and temperament of the person in office played a big difference in the Depression. And of course, you can draw your own conclusions about the differences between today and then.
Great. We have a question coming in from online. It's actually our most voted question. The question is, does social media contribute to democratic erosion?
It's kind of ironic that's coming in through social media.
Well, it's obviously a huge question for every democracy, and something that no one's really figured out quite how to handle. Obviously, in our tradition with the First Amendment, a government solution is not really going to work here. And so any solutions to the problem of fake news, the problem of hate speech and such, which is very real and has very real consequences. In places like Myanmar, consequences of ethnic violence in our country, just consequences to the democracy, to the quality of trust among citizens. It absolutely has effects. We just don't really know yet how to handle it.
We'll take a question just from the corner of the room right there, lady.
Hello. So I had 2 questions, really. The first of which is, the Constitution's been called like American scripture by some historians, and it is essentially something that did sort of lay the groundwork for what is America. So to what extent do you think it genuinely is realistic that we would be able to edit, amend, or change this document and still ensure that it is something that is by the people and for the people? And my second question is, to what extent do you think it is still a document that's very much relevant to our contemporary society, especially given the fact it's reflecting the views of the Founding Fathers from 1787, and we're very much in a different time now?
Well, maybe I can answer first. I think that it's having profound impact on our society, and that's exactly what our book is about. It's about the specific ways, sometimes very minor clauses, are shaping our entire political structure, our discourse, and our institutions. And so it's absolutely critical. How realistic is it to change? Well, if this convention comes about, it is going to change. Of course, we have the way that formal amendment works. It tends to come in waves. So you had a big round of formal amendments in the progressive era. And if we get to a new progressive era, maybe we'll see a return of constitutional amendment as a device for changing the Constitution. But in the civil rights era, we didn't use formal amendment as a mechanism for change. Rather, we used statutes. Some legal scholars call these super statutes, things like the Civil Rights Act or the Voting Rights Act, which are just hardwired now into American democracy. So I think the most likely scenario is workarounds, right? That we have this structure, it's got some real flaws, it's really hard to change. We probably don't want to tear it up and start over. It'd be very hard given the religious reverence we hold the document in. So we're going to have to come up with workarounds that make our government workable. And we think there's a lot of possibilities there.
If I can just say one thing. So the Constitution is like a scripture in as much as it is venerated but not read. And the fact that it is venerated, not read, and majestically ambiguous means that it is plastic and capable of taking on the coloration of an era in ways that actually is very much akin to scripture, right? An example of that that's not contemporary is just before the start of the Civil War, Frederick Douglass gave a speech in Edinburgh in which he stridently insisted that not a word in the Constitution was consistent with the institution of slavery. And I assign this speech in my, when I teach constitutional law, in part because otherwise you'd get through the first 100 years of American history and not read anything that's written by a white man. But in part because it shows the capacity, the resources that an ambiguous text contains, even for the group that was subject to the sharpest and most extreme form of oppression and even annihilation up to the Civil War. Right? That's the virtue of the Constitution, or that's what makes it like Scripture. And even if you can't change the Constitution, you can change the implements through which it is read. 100 years ago, most people on the political left were incredibly skeptical of the idea that courts have some sort of special authority to read the Constitution. Most people on the left, as our colleague, the historian Laura Weinrib, has written, were deeply averse to the idea that the Constitution belonged to judges as opposed to the people, right? And even if you keep the Constitution, it turns out that the open texturedness to ideas and the variation that's possible with respect to the tools used to give it meaning create all sorts of openings, right? So yeah, I hear a British accent say, yeah, yes, they are stuck, right, with this 230-year-old thing, right? Which I point out to my kids is as old as the steam engine that we go and see in the British Museum that was created by James Watt, right? It's the first steam engine. It's as old as the Constitution, right? And it's twice the size of this room. Yeah, it's a really old and not particularly well adapted technology. But look how many different ways there are of using it.
Great. We're going to take two more questions. I'll take one from online and then one from in the audience. The question from online says, we're just 5 days away from the midterm elections. What do you think about the current electoral system within the U.S.? And then do you think that our current political polarization is weakening our democracy?
Well, we're not big fans of the way elections are run in the United States. Of course, there's great state-by-state variation. And one of the things we suggest is that the secretaries of state ought to get together and have more common standards. I think there's real technological variation, to say the least, including technological vulnerabilities, right, to foreign manipulation. And that seems like it'd be something in both parties' interest to address head on, to have standards for common electoral norms and such, to get rid of hanging chads and such. And so there's a real need for that.
And then we'll take a question all the way from the corner, our last question.
Yeah. So I just have a question, I guess, for both of you, one political scientist and one a lawyer. I also went to law school and recently passed the bar exam, so definitely have a question for you, my friend. So in regards to, I guess, the degradation of democracies in regards of economic freedom, what's your opinion around the world insofar as, like taxation and regulation, and do those come into play in countries, I guess, like Venezuela that regulates pretty much every aspect of the economy as opposed to other countries that have a freer economy? And then the second question is regards into the Commerce Clause. where the United States pretty much has a really broad interpretation of the Commerce Clause, in that there was not one law from 1937 till I think 1991 that was struck down under the Commerce Clause. And so I guess they're both economic questions, but I guess one's more of a political science question and one's more of a legal question.
Yeah, maybe I'll take the first one. Our definition of democracy is really a thin one. You have to have elections for sure. You must have the rule of law and a certain set of rights, freedom of association, freedom of speech, which are necessary as the legal underpinnings of democracy. And I'll just add, I'm a lawyer too, so I can say something about legal underpinnings with a straight face. But beyond that, we don't say anything about it. So our definition is consistent with a social democracy, even a socialist system, and it's also consistent with a libertarian political economy. That's what the people should be deciding, and it should be based on their own preferences. So we don't bring that into our definition. I'll turn to you.
I would point out two things on your first question, and then I'm not sure if I understand the second question, but I'll have a go at it. The first thing is that you see populist, anti-democratic movements emerging on both the left and the right, and adopting different packages of regulatory measures which are either more or less, let's say, Keynesian or Hayekian. So in terms of the observed preferences over economic policy, there doesn't appear to be much of a strong correlation. Can I use that word? I'm not a political scientist.
Correlation is okay. We'll let you use that.
Okay, I've got permission this one time. You don't see a strong correlation between economic libertarianism and either anti or pro democratic movement, at least around the world today, right? So that's one point. The second point is this. In a system where there is a good deal of regulation, particularly of media markets, those instruments of regulation provide tools to sub rosa, under the table, undermine democracy. So one example is in Hungary, the reconstituted Independent Media Board drove out of business the company that rented billboards to Fidesz's opposition, right? So they used that authority, a form of economic regulation, in an anti-democratic fashion. So now, really, you can only see Fidesz billboards in Hungary.
And George Soros pictures.
And, well, with like little horns on them, yeah.
Yes.
Right. The other example from the US is there have been a series of regulatory decisions, largely by the Federal Trade Commission, with respect to the application of the antitrust laws in the media domain, respecting cable companies and other media intermediaries, that last week were challenged by a group called Protect Democracy on the ground that the reasons for denying or expediting these regulatory moves, mostly again about antitrust, right, were related or were driven by a partisan rather than a proper regulatory agenda, right? So those are examples of regulatory authorities in the economic domain being put to the end of democratic backsliding. Now, to go to your second question, I think those tools are made available by the fact that the Supreme Court, interpreting the authority of the federal government to regulate commerce under a part of the US Constitution which you referred to called the Commerce Clause, right? The Supreme Court has broadly interpreted that authority, at least since the 1930s, and that's what creates the space for these economic regulations. Judging that broad national authority to engage in economic regulation, I think that the balance that one has to evaluate, and it's a balance that everyone will evaluate perhaps somewhat differently, is, well, what are the benefits that have come from having a nationally, federally regulated economy? And what are the risks and dangers that come with it, right? And I think until recently, most people would have identified the economic libertarian concerns as being risks, but they wouldn't have said that regulation, or the power to regulate it, could itself be a risk to democracy. And I think that's what we're starting to see a little bit of.
Unfortunately, that's all the time that we have. Please join me in thanking our speakers today.
Thank you.
How to Save a Constitutional Democracy will be available for purchase and signing. Thank you for joining us.